Get started. Technical folks here, we're good to go. Nita, can you hear okay? Need rights online?
Yes.
Trust you'll let us. Okay, great. So quick introduction. So I'm Aaron Hood. Several of you I have not met before today, but I did get a chance just to meet Doug and Laura. So welcome everyone. Thank you for your time this afternoon. I'm the current interim chief administrative officer, AKA the new Justin. So sadly, Justin moved on from us. But I personally have been with the court 10 years this month. That's hard to believe. And so previously I've been the chief financial and chief operating officer. So when Justin left to kind of fill the gap with the CAO role, the chief asked me to step into that. We have that position posted, so we're taking applications looking to fill that in the coming months. But for now, you're stuck with me. I've never had the opportunity to attend Interstate Compact before, so bear with me as we navigate through this. But just want to officially welcome everyone and call us to order here. And then next up will be attendance. Probably typically the chair just calls that, but I'm just going to ask if we would go around the room, introduce ourselves as we do that. So Antonita, do you want to kick us off and just say who you are and where you work?
I am Antonita Brooks, and I am new to the Interstate Compact. So I am a Interstate Compact specialist. I come from court technology, so Supreme Court technology prior to.
Welcome.
April Simmons. I do Interstate Compact, reporting instruction, sex offenders, and currently incoming and outgoing cases until we get more staff.
I'm Chris Bean. I'm the director of the Justice Services Division. I suppose most proximal is I'm the commissioner for the adult and juvenile compacts in Indiana.
Great. Jenny.
Jenny Bauer, staff attorney in court services and a longtime staff person. Sorry, Jen. Could you? Oopsie.
Yes.
Jenny Bauer, staff attorney in court services. I'm the longtime staff member to the council.
Recently promoted.
Oh,
Congratulations.
recently promoted. Thank you, Aaron.
Sure.
Yeah, so.
Laura Berry, Executive Director of the Indiana Coalition Against Domestic Violence.
Great.
Doug Hunsinger, Indiana Criminal Justice Institute.
Excellent.
I'm a guest, Catherine Poi, Indiana Office of Court Services.
Bernice Corley, Executive Director of the Indiana Public Defender Council.
Okay. Nita.
Hi, I'm Nita Wright, Director of Interstate Compact Compliance.
Appreciate our support staff real quick.
David Sexton, Indiana Office of Court Services.
Rose Walker, Indiana Office of Court Services.
Riley Summers, also OCS.
Great. Thank you all for your help. Okay, next up officially is to review and approve the July 25th, 2025 meeting minutes. Ooh, good question. Do we? We are missing several folks.
Everybody's count. I don't know.
Math time.
Count.
Everyone do math here.
Solid question.
I show 11 numbers.
Yes.
Is it 6 or 7 we need?
Probably simple majority, isn't it?
We need
Yeah.
6.
Yeah.
We just can't move.
Okay.
Maybe somebody's coming up the elevator.
Aaron, it's not you. It's happened before.
Okay.
No, it's not.
Yeah,
Thanks, Denise. Wow. All right. Well, we'll sit.
Actually, if we could just talk about it for a second.
Sure.
So I'm wondering, DCS, their director has been out for a while, so I wonder if anybody there even knows
Yeah.
that they need to send someone.
We could reach out to Jennifer, who's filling in as interim. So.
And I've communicated that with Waylon James, who
Okay,
I believe is still handling ICPC for them,
Okay.
but I'll make sure that more direct
yeah,
communication.
I don't know if our emails are going into a black hole over there or
Sure.
anything.
Sure. Okay, well, we won't approve the minutes at this point without a quorum. And then next up, the topic adult and juvenile compact updates. So April is going to handle that for us. So April, take it away.
So we met in the fall of 2025 for adult compact, and we approved the rules, updates and changes that were effect April 1st. We had a training on a statewide training on March 12th, which we had 119 individuals attend. A lot of the rules now are focused on keeping the individual in that state. Beforehand, we had rules where you can easily retake your offender, or you could have a warrant issue. So now the rules are more into effect as we're trying to do community supervision as opposed to punishing the individual. With that being said, we had a work needs and responsibility work group that was formed, and they piloted a retaking initiative by states. So now what states are doing is there is a matrix system that you have before you do a violation. Beforehand, it was like, okay, this meets the threshold for our state. We're going to send a violation report. You must retake that individual. Now it's looking at their community support, the risk level, what the offense is, if they are employed, if they have stable housing, supervision levels, and then they take all of that into account before they decide if they're going to send a violation report back. So we have individuals now where, yes, they committed a felony conviction, but the state has the option to let them remain there because, for one, they'll be under community supervision in that state. Or if we send them back, it's more detrimental for them to go back to where they have no resources to start all over again. So instead of just looking at the rules from black and white, we have a gray area now, and it's working with the probationer, and we're just not tracking people across state lines or actually trying to work with these individuals. So that's something that's new. It's not all states have adopted it. We did a pilot program. What I think is going to occur is in 2026 and beyond, they're going to start implementing this, so we could see this happening more often. The national office has a new IKO's website that rolled out. It's supposed to be more user-friendly. I don't know if that's the case, but it looks nice. And then in regards to compliance, we continue to meet our compliance. Actually, we exceeded. The threshold is 80%, and our categories are in the high to mid 90s across the board for everything. So we're doing well with that. Our counties are finally on board with understanding that compact supersedes what they do in their own county. So judges have been on board, prosecutors, everybody's working towards making sure that we maintain compliance. And with that, that's all I have. Does anybody have questions?
Yeah, Bernice.
April, can we talk back to the matrix? Is it possible to share with this group? If you've shared it before, I just don't recall it, but can we see the matrix, what it looks like?
It's a hand. Did anybody see the handout?
Oh, I missed
It's at the front table.
Thank you, Bernice. I didn't see it.
So it has case information on there for the individual. Then it goes into the severity of the violation, and it starts with low, medium, low, moderate, high, very high. And then you go to the stability factors. It has the connection to the receiving state, employment, support system, treatment, supervision, conditions and case plans, and then prior violations. So you check off yes, no, you tally all those categories, and then you come out with the number 19. So then you do your recommended response. So before it was, if you have a high-risk person, they are employed, they have stable housing, they have family there, but they're testing positive and they're not in treatment, and they pick up a new arrest, they're like, oh, go back to your state. Now, those factors are working for that individual. So they're trying to make sure that they put support system in place. Yes, he's in treatment, but they continue to test positive. What in addition can we do, or what kind of wraparound services can we provide for this individual to make sure they're successful in that state and keep them in that community? So it's more towards wraparound services basically for the individual.
That's great. I mean, so once this matrix is completed, is there a scale that the person using it can look at and go, okay, this person scored very, I don't know what is good or bad, high or low, but scored in such a way, how should I interpret that number? Is this person high risk? I should go ahead and send them back, or their numbers are green or yellow, meaning they're cool to stay? Like, is there?
It's high or low. And then also what is happening is causing states to have conversations now. So just because they are high, you can say, okay, they're high, but we're going to keep them there. There's this thing called discretionary retaking. So even though the receiving state is not retaking that person, the sending state can say, I don't like how you handled that. We're going to retake them anyways and order them to come back. So now it's causing people to have a conversation. Why are you not submitting a violation report when we clearly want to retake our person? So it's just working with that other state to say, yes, we understand that, but he does have this small thing that's happening, or they have this small thing that's going on that it's positive, and we think that staying here will be more beneficial.
Got it. I mean, it seems really great. So maybe there's not a scale for them to look at the number, but it stops and requires a conversation,
Yeah.
right? And a real examination of the person and are they stable and how do we not disrupt that stability?
Yes.
That stability. One last question on this. You said at the end, and forgive me, I was multitasking, so I want to make sure I heard it correctly, that this tool has not been adopted by compact states. What does that mean? So is this just a pilot right now?
Yes,
And it
ma'am.
will become, perhaps.
I'm gonna say it will become. So there's 9 states who did the pilot program that ended in the fall of 2025. So actually, no, March of 2026 it ended. So now they're looking at the research to see how we can get it moving forward. Change obviously happens slowly, so we didn't want to dump this into states' laps, like deal with it. So we're implementing it step by step so people can get used to it and accustomed to doing it this way. So then moving forward, it's going to become organic to them and it's just naturally occur.
Thank you.
If I could add one thing.
Sure.
So Bernice, one thing, and this is kind of from just the world of community supervision in general and using the evidence-based practices. And so one of the things they call it's R&R, it's risk, need, and responsivity. It's looking at kind of behind the behavior, why, what's going on. It's like April said, what else do they need that could support them to be successful and not just kind of looking at the behavior and going, oh, we're done with you, let's move on. So.
It's great. I
Yeah.
mean, I feel like we should be, maybe we are in some communities doing it within our state when we're thinking about technical violations and people going back to DOC and things
Exactly.
like that.
That's where it's gonna take a lot of work is our local counties, because I'm like, you can't send them back. Well, they had 3 strikes. Like, so the old school mindset is you have 3 instances of noncompliance, we're gonna send the violation report. We understand that, but now we're trying to move towards case management and making sure our responses to their behavior line up with what we're doing. For example, this week, I talked to Nita and Antonita about it. A person tested positive, and so in our county, and they sent a progress report, but they gave them 8 hours of community service work. That does not line up with what they need. So we had to send it back and say, have you tried self-help? Have you tried substance abuse, inpatient, something that is going to help them be successful? Because completing 8 hours out, he's probably going to do that and go right back to testing positive. So something that's going to make that individual stop and identify their behavior with their needs and their consequences.
Great, thank you.
Any other questions for April? All right, thank you, April. I'm gonna put us back out of order a little bit and head back to the minutes. Since Tracy's here, we have a quorum. Welcome.
About that, I
Not a
got
problem.
Stuck on a call.
No problem at all. Welcome. I'm Aaron Hood, the interim chief administrative officer. So that's why I'm doing the chair bit today. So if we could go back to the minutes for July 25th, 2025, are there any changes or corrections to the minutes? If not, I would entertain a motion to approve those as submitted.
So moved.
All right, is there a second?
A second.
Motion second to approve the minutes. Anyone wish to speak to that motion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Motion's carried. Minutes are approved. Thank you. Okay, and then we just finished the adult side of the compact, but now I'm going to turn over to Nita to talk about the juvenile compact topics.
Hello, everyone. For the juvenile compact, At the 2025 annual business meeting, new rules were approved. Those amendments were approved, I'm sorry. And included with those amendments were enhancements to our juvenile system, which we call Unity. There were a total of 9 operational enhancements and 4 workflow enhancements. And so as I give those enhancements, it's also touching on the rule that corresponds with that. So I'm going to do them all together. So I'll start with Rule 5-103A. It's now called mandatory relocation. This rule used to be called, it was formerly failed supervision. And when a juvenile violated their supervision, they could no longer live at the residence. Perhaps it was because of behavior, treatment, for whatever the reason, that was considered a failed supervision. However, it did not capture those juveniles who needed to relocate that was unassociated with their behavior. Perhaps the sponsor no longer wanted the juvenile in their home, or for whatever reason. This, regardless whether it was failed supervision or nothing correlated with a violation, it was mandatory that the sending state relocate that juvenile, whether it's in the receiving state or if they have to bring them back to the home state. And so this rule was changed to closely more align with what was happening. Just because they have to relocate doesn't mean that their supervision failed. So the sending state has a term of 5 days to find a new location for that juvenile or a new placement, and they can continue on with their supervision in the receiving state. Versus a failed supervision, most of the time it was get them a location or get them back to the sending state. So this is beneficial to the juvenile and goes in line with more of helping them and giving them the services that they need and making sure that we are keeping them where their legal guardians are. Rule 4-104, conditions of supervision. With the prior rules and the home evaluation, they would give the details of the home evaluation, but there was no rule indicating that it was mandatory for them to identify any conditions that they could not support. So this new rule put that into effect, and it coincides with the current adult rules. The adult rules have it, but the juveniles did not. So now when they're doing the home evaluation, if there are conditions or conditions of probation that they cannot help that juvenile meet that they don't have in the county, this information provided to the sending state helps them to determine their next steps with the juvenile, whether they're going to modify that supervision, provide an alternative condition. So again, it helps the juvenile, helps the family with continuing on a successful path for supervision. Rule 4-103, a new 10-day business calculation. This coincides with the rule where it's no longer a failed supervision, but it's a mandatory relocation, and it resets that date to 10 business days to get that satisfied. Form 1 and Form 2, which are involved with the requisition process, the ability to reject it. When we did that previously in the system, whatever the the receiving state sent out to the home state, they were not able to send that back if there was corrections that were needed. So what would happen? There will be a lot of behind the scenes communication that was not documented, things going on that were not in the system. Having the ability to reject it with that functionality in the system, it creates a log of why that information was returned, what was needed to continue with that requisition process. This helps to expedite that process because, things can get lost in translation over the phone, just mishandled paperwork. So everything goes in the system and it can now be documented. And the state that receives that requisition can send that back, and they couldn't do that before. Of the operational enhancements in our system would time out. There was a known 30-minute timeout, although I believe it was actually operating on about 15 minutes. There was never a warning. You could be in the middle of something and it's telling you to log in again. And so they created the session timeout warning. And you have the option now to extend your session, which will create a new 30-minute interval. Or you can cancel your session and then it saves your work and you can go back in later and continue where you left off, not just abruptly end your session. There are also, for the enhancements, what's called a halo option. In the system, there are mandatory fields and there are fields for optional information. And many times, because that information is optional, our local users don't put it in, but that doesn't mean that it's not necessary and important. So they now put halos over that information to bring that attention to those fields that we're asking you, if you have the information, put it in the system, because more information is better than a lack of information. The transfer or supervision of verbiage, some of it has been changed. What this does is it clarifies what assistance is needed and in obtaining signatures. For example, there's a Form 6, which is the agreement to return the juvenile waiver. That requires the judge's signature and the juvenile signature. Many times the juvenile has already left the state. They have the judge's signature, but not the juvenile signature. So they're asking the receiving state to assist with obtaining those signatures. And although that functionality was built into the system, it was sort of towards the front. And while you're digging into the case, you may miss that signatures were needed. And a lot of states were sending forms back and cases back saying you're missing the signatures. And it was creating additional time in processing the cases. And that was a compliance issue, as well as it was taking longer to process those home evaluations, which means that juvenile was in a state without the supervision of that receiving state. They were still under the supervision of the sending state. And so this kind of helps to expedite that and clean up those gray areas, and to point out that the receiving state, when asked, please help and assist with getting those signatures and not allow that to stop the processing of the home evaluation. Arrival and departure dates. In the system, it was a bit confusing. It said arrival date and departure date, but it didn't say for what. Was it the date we're departing the sending state and arriving in the receiving state? And that's oftentimes the dates that were entered, and that was incorrect. The correct verbiage is saying what date is this juvenile going to arrive in the receiving state, and what date will they leave the receiving state. So if they're on a travel permit, we need to know what date they arrive and what date they're out of the state versus what date they left our state and made it to the receiving state. So that provides clarity, and also it enhances community safety because we have accurate dates reflecting when that juvenile was in and out of a state. Another functionality issue we were facing, it was mandatory that when a juvenile has a travel permit, that the juvenile signs the travel permit and also the person authorizing that travel. If those signatures were not included on the form, when the other state received it, they were often rejected for correction. So what they did was, it is not a rule that the officer has to sign the travel permit. It's a rule that they're approving the travel permit. So we want to know who's approving that travel permit. So it's just an automatic function that was added to the system that it automatically puts the signature of the officer approving that travel, so it's not forgotten on the form. So if a juvenile is not signing, most often the officer wouldn't sign the form. They would forget to sign the form. So in the system, it advances their signature even if they don't have the juvenile signature, and therefore, again, closing that gap of a longer time of processing cases. Another event was to reopen a transfer or supervision case. Again, when there are errors or for whatever the reason is that case needed to be reopened, it puts a new 10-day countdown on that. So let's say a juvenile is in the receiving state. They already have a home evaluation going along. That home evaluation was denied. The case was closed. instead of having to create a whole new case, you can reopen that case because it could have just been a quick movement of documents. You can reopen that case, and now there's now a 10-minute, I'm sorry, a 10-day count on that for moving documents along. 10 minutes, that would be miraculous. Okay. Document deletion rights. So we created this new beautiful system, but all of the compact offices had the ability to delete documents, even from the receiving state. I'm sorry, the sending state. So we could delete documents that we didn't have privilege to delete. So they corrected that error in the system. You can only delete documents in the state compact office belonging to your state, and it's at the highest level at the compact office. Within the counties, a supervisor can delete a document if they created it, and the same for a user. If they are the creator of that document, they can delete that document until it crosses state lines. So that clears up anyone deleting important documents, someone trying to hide information. It puts the integrity on the information that's in the system. And when there is an error, proper protocols and safeguards are put into place to protect those documents. Correct the 24-hour return for a return release. What that means is when a juvenile has been verified as being free to be released to their legal guardian within 24 hours, they are usually released without executing the compact. So we use the compact to do the verification process, but we don't have to formally go through with a Form 3, giving them the opportunity to voluntarily return. They can be returned to their legal guardian as long as they don't have any holes. And what was happening is sometimes quick fingers would mark that the juvenile was returned in 24 hours. Maybe the mom or dad hadn't picked up the youth yet. They're en route and something happened and they stayed in custody over 24 hours. Well, once a juvenile is held over 24 hours, we now have to effect the compact. They now have to be given their rights, and we have to allow them the opportunity to voluntarily sign the Form 3, which says they consent to return to their legal guardian. And when that happens, we need that case open and the functionality and routing to be correct. So we now have the opportunity to cancel out that juvenile was released within 24 hours, and we did not have that before. Our locals will have to create an entirely new case and go through the process, and that was very time consuming. So this corrects that process.
Nita, sorry, Nita, this is Jenny. That's for runaways?
Correct. Yes, that is for returns. Yes. And the last operational enhancement concerns returns and air travel. Currently, the travel plan that a home state will offer to the holding state, it could identify the starting flight, a connecting flight, and then the information on the receiving end. But it did not capture states that have multiple airports in their state, and that juvenile may have, such as Texas, that juvenile may start off in one airport, fly to the next airport, but they're still in the same state. So we needed a way to capture that information where that juvenile had surveillance in their own state and not just a receiving state or a middle state. So there are ways that it was being done, but it was not accurately reflected in documentation. It was a lot of communication over the phone and emails, but this keeps all of the information with the case. It also creates, it stops creating confusion when they're en route and they're transporting the juvenile through TSA, and TSA looks at those documents and they say, oh, this is the travel plan. I see you connected from A to B to C to D, and it has all of the connecting information. So that was a really important change and enhancement that we are all grateful for, because it happened more often than it didn't. For compliance, we are under a new compliance parameters where we must obtain at least a 90% approval in all of our business. Whereas previously it was in the 80s. So that's a higher threshold. And although we already operated in a higher threshold, we want to make sure that we're not just doing it because we've gone above and beyond. We want that to be the standard. So we are training our users on accountability, being more conscious of those compliance states. A lot of the business that we do, there are certain policies that we have that are not compact rules. For example, the state has 45 days to complete a home evaluation. Well, that's for the entire state. That is all of that 45 days does not go to the county. Technically, they should have that home evaluation done within the first 30 days. And the rest of that time would have been for the compact office to get that information, review it, make sure it's correct. If something needs correcting, we have time to send it back to the field and get that corrected and still meet the 45-day compliance. As a courtesy, the compact office has given our users more of our time because everything is electronic. And we have a fairly good group of users that are pretty consistent on compliance. And so we've offered them some of our days. And so we give them 10 days prior to the 45-day compliance date to have that information into us. And if we find that they are not meeting that, then we will have to make some changes and go back and take some of our time back because we must meet that compliance with that new higher threshold. It's more pressing now than it has ever been before. Under the new compliance, it runs quarterly now. So every 3 months, they're going to do an audit of our work. We do not yet have the results of the first quarter, which ended March 31st, but we are expecting those soon. One of the delays was due to the launch of the new enhancements in the system. And so there was some issues with the launch, and therefore there was also some issues with the information that was coming back. So they want to make sure that that information is accurate, that they're going to deliver to us. And that's all the updates I have for the juvenile compact. Are there any questions?
Okay. Thanks, Nita. Appreciate that. Next, we're going to move to other business. And first item under that is Mr. Chris Bean here with some staffing update news.
All right. Natalie Sevilla left the Office of Court Services for the end of 2025. Laura Housladen, who maybe many of you knew, retired. She is no longer with us as of April 1st. We welcome Antoinita on this already sort of overworked team. That is the extent of my staffing update.
Okay. Any questions?
Does that mean you're down just one person or two?
Currently down one person. Yep.
And what do you guys plan on filling that? Or?
We will. Yes.
Okay. Any other questions for Chris? Anything else for me?
No.
All right. Any other business from any other member this time? Okay, moving along here on future meetings. We'll have to reach out. We don't have a future meeting set at this point, so our team will be in touch and we'll get one coordinated and send out the invites when we're ready for that. Then lastly, unless there's any other items from anyone, I would look for a motion to adjourn.
So moved.
Is there a second? All in favor of adjourning, please say aye. Any opposed? All right, we are adjourned. Motion carried.
Bye, Nita.
Bye, Nita.
Bye.
Thanks, Nita.
Hi, Nita. Thanks
Nice
for
to
talking
see
all
you
the
all
people.
again.
Tracy says thanks for talking to all the people I sent your way the last couple of weeks.
Oh, thank you.
I do. I've got a kid in Kentucky.